Hi, ladies and gentlemen. We are back with the SAP IP Business Talks. Today, as you expect, we talk about UPC and some insights to the question how to build a litigation strategy. My guest today is Chris de Mauny from Bird & Bird, and I expected to find him in San Francisco, but I learned that this time he is in London. No, he is in UK, not in London. He is in the south of the island. Some housekeeping remarks. We are live here on LinkedIn. That means we can see your comments and your questions, and it would be great when you have something which you want to integrate to be asked, that you tell us that, and then we can pick it up and discuss it. So, Chris, thank you very much for taking the time. Thank you very much for being with us. And even when it is a bit confusing that the San Francisco bridge is behind you, you told me that you're in London. So, Chris, first of all, how did you came into this strange field of intellectual property?
Thanks, Alexander. Hello, everybody. Yes, I suspect my story is not so different to some others, but I studied chemistry and material science at university. I had originally had a really strong interest in science. I wanted to know how the world worked and be curious about finding out how the laws of nature affect us all and that kind of thing. And I think when I started that process, it was the big picture things that interested me, quantum physics and chemistry and things like that. And I ended up in a situation where towards the end of my master's degree, I was kind of going into a lab and turning a machine on and going away overnight and coming back and looking at the results. And it was cutting edge metallurgy research, but it wasn't actually that thrilling for me. So I looked around for something else and returned to an idea I'd had earlier in my life of potentially becoming a lawyer. Originally didn't think about doing IP specifically, but I encountered at a careers event, I encountered somebody who's now a KC doing patent law day in, day out, and he encouraged me to look at that. And I thought this is a fantastic way to combine my interests and expertise in the science and technical fields with this idea I've got to do law. So I very much got into it at that stage, at the age of, 22, 23, and haven't really looked back.
Thank you. Okay. So today we want to talk about UPC. So to the audience, we have online an industry focus on UPC from a market perspective. So we try to describe what's going on in this IP field, in this IP market, to understand better who is doing what in that field. So feel free. We have also a complete market study there. So feel free to download and to inform yourself what's going on. So when UPC is discussed, there are lots of different perspectives. So we have here in the IP business talks an IP management perspective on it, not so much legal perspective, but obviously you cannot separate it really. So it has to be an integrated thought, and that means there's also always a strategy behind it, a strategic thinking, especially in litigation. So that is costly, it takes time, it binds resources. So obviously there should be a strategic thought behind that. So when we see the development out there that UPC has become a central venue for patent litigation in Europe. So this is the development, and everybody expects that nothing else will come up. That is what we have to take into account. And so, what would you say when an international company, let's say from outside of Europe, when they decide to litigate before the UPC or national court? So what should be the reasoning behind that? What should be the strategy? And in addition, maybe can you tell us which kind of arguments support a certain division on which you should choose?
Yeah, of course. And I suppose, as you outlined, I'm currently based in San Francisco, and I have been since only a few months after the UPC began. So my perspective on this is somewhat influenced by the conversations I have with people on the West Coast who are, of course, not based in Europe, but not necessarily representative of the whole world. But the way I see it is that one has got to be clear about what the commercial litigation objectives are, and then assess the various characteristics of the forums that you are examining to see which ones work best. And in doing so, you've got to have an understanding, therefore, of what is on offer in the UPC and what is on offer by comparison in the national courts that you might use. And if we examine the characteristics of the UPC that most companies are looking at in this kind of analysis, one is what I'm going to call the power of the UPC, the fact that if you've got a widely validated patent, you can get a remedy that covers so many countries. I mean, let's just start with the 18 UPC countries for a start, and we'll move on to extraterritorial jurisdiction later in our discussion. But you've got at least those 18 countries covered in one go. And it's not just that they're covered, but the cases that we see very much support the proposition that an injunction is going to be granted, and that it is going to be granted relatively quickly, by which I mean perhaps something over a year, 14 months, maybe 16 months, something in that time range. So the power, as I'm calling it, of the UPC system is to get to a wide-ranging decision quickly, which gives you this remedy, which you can then use as leverage in negotiation, or you can use it to simply exclude from the market if that is your approach to these things. That is very superficial, but quite straightforward and easy way of characterizing what the UPC offers for people who are kind of dipping into this system. If you then look at the alternatives in the national courts, the two main things that I've highlighted are where the differences lie. Many of the national courts are much slower. Not all of them, of course, and some can be very fast, but many of them are much slower. And leaving aside extraterritorial jurisdiction, you're limited to getting a remedy that applies to that one country. So as soon as you have interests that you're trying to protect in multiple countries, you're going to have to file multiple cases. They'll progress at different rates. You may get different outcomes. You'll need different teams of lawyers. You need to coordinate between them. And all of this is potentially unattractive. Now, I say potentially unattractive because it goes back to what are your commercial objectives. If you have a patent that you believe is likely to be valid, it reads onto the product or the process you're worried about, and there's widespread infringement, and really what you want to do is get that injunction as quickly as possible, then that clearly mitigates in one direction. On the other hand, if you're not so sure about whether the patent is going to be valid and you want to fight a kind of long-running war of attrition, which some companies do, then perhaps the UPC doesn't offer what you need, because the very advantages that it offers for some are not advantages for you, because your patent will be found valid or invalid, but potentially invalid within 12 or 14 months across all of the countries that it's validated in the UPC region. So understanding the different things within the court's systems and how they map onto what you're trying to achieve. That's the very big picture. Of course, there are things around what kind of evidence may you need to make your case good. Are you going to want to rely very heavily on arguments that are likely to need support from expert witnesses? And is a particular forum the right one for that? We see expert evidence used in the UPC, certainly, but not being used to the extent that it is in, for example, the UK, or indeed, of course, the US courts. You might need certain types of evidence to start your case. Do you know how the product works? Do you need to seize samples? Do you need to get at source code? Do you need any of these kind of things? Or perhaps are you better off in a system where you can plead out what you have and turn the tables on the other side to disprove your case? So these kind of things are very much more nuanced and much more case specific, and it's very difficult to say at a large scale, the UPC will do this for you, or this national court or that national court. But they really factor into a real life decision as to what forum should be chosen. I think then if we make the assumption that people are looking closely at the UPC, then the next choice is where, in which local division or potentially regional division am I going to file, or potentially a central division in some cases, but where am I filing my infringement case? And that, I think, is a more challenging question, especially for litigants who are not regularly using the system. And the reason for that is that if one looks at what others are doing, there's a very high rate of filing in Germany. There's absolutely nothing wrong with that. And I can fully understand why many people have thought that filing in Germany is the right thing for them to do. They have good judges, they have good lawyers, etc. If you look at the statistics on how cases have been determined, they don't indicate that filing in Germany is beneficial. I certainly am not saying that they indicate that filing in Germany is a bad thing. Absolutely not. But they don't support the proposition that you're more likely to win overall by filing in Germany. And so I think one should look at a number of different factors if you're making that choice between division. Who are your external lawyers who are helping you? Where do they feel the case will best appeal around the judges that they know that they're going to have to address in court? Where are you best placed if you need something like an evidentiary seizure or a preliminary injunction? Of course, there is case law in the UPC, and in theory, you should get the same PI wherever you are or not. But the predisposition of the judges is certainly important, and particularly around factors like urgency or the relevance and the assessment of the commercial factors favoring either the plaintiff or the defendant's interests. There might be more substantive issues like any expectation that you're going to need to rely on the doctrine of equivalence, for example. And again, we have some emerging case law, but one can look at an expectation for how judges might assess certain arguments based on their experience from national court litigation and the case law that they're used to from their own countries, until these matters are really dealt with on a very authoritative level by the Court of Appeal. So there are all sorts of issues like that, where it really matters understanding what the nuances are between the divisions. But I would say that actually, if you look at those statistics, ultimately the win rate is not coming out particularly different between different divisions, or not in a way that you could pick out a division and say, that's where I'm most likely to win.
So what you said, and there is a comment from Arthur above in the chat, and he also focuses on speed and says that even complex cases you can get a relatively fast decision. But he says, and this refers to what you said, at least implicit, that it has to do with experience. So on the one side, from the users of the system, so the patent owners, on the other side also, especially on the attorneys or lawyers. So I would say, so what I see in the market for UPC is that there is a relatively small, a little elite of lawyers who accumulate a huge amount of experience, and that is a very strong concentration effect at the moment, and I can't see how that will change in the future. So it's really, I wouldn't call it a bottleneck, but it is really a relatively small number of people who get this experience, and others have more or less no chance to get any foot on the ground on this area. Is that correct, or you don't think so?
I think there's a lot in what you say. There's certainly a concentration of work in if you look at how many law firms there must be across Europe who have UPC representatives, there is a concentration in work in a relatively small number. I don't know if so our firm is handling about 1/7 of the cases altogether. And I think we're not the largest proportion. So you can see that the concentration of cases in a relatively low number of firms is there. I think there are certainly a few firms who are handling one case or a couple of cases as well. So to an extent there is that. But I agree, in a new system where in principle people all had, as it were, the same chance of getting up to speed and getting experience of the new system, it does seem that those who had more experience in the pre-existing systems have attracted a large amount of work and kind of almost accelerated away, if you want to put it that way. And I think that's reflective of client choices, that they've put confidence in the people who they have had confidence in when working in the litigation systems from the national courts. And if they haven't had that experience, they've relied on confidence expressed by others. And there is a high degree of rationality to that, because although it is in essence a new system, it's building on features of the national court systems, and of course drawing judges from those national court systems and experience from those is hugely valuable, notwithstanding that you're dealing with a new set of procedural rules and certain issues of competence and division, allocation and things which are completely new.
Mm-hmm, mm-hmm. So I think the speed requires also certain preparation, which means so when you start a UPC proceeding, that can or typically will move quite quickly, and that means and it's obviously a lot of work, and also the firm, the company, has to be prepared to that when they are the patent owner, especially when we have any kind of provisional measures when they are requested. So what would you say? So how can a company prepare to that, and what should be the reasoning behind that to be, so to speak, litigation ready?
Yeah, that's a good question, and I think you can look at it from either the patentee or the defendant's perspective. And at one level, it seems like the patentee has more luxury of time because they know their own patent portfolio. They can invest in thinking about the arguments that they would bring to bear, potentially without the pressure of a filing having been made. But of course, they have to deal with the urgency requirements. And if they suddenly come across a threatened infringement or an infringement that's just started, then they can equally be under a lot of pressure. So I think one can definitely look at it from both sides. I think from a plaintiff's perspective, the patentee's perspective, a lot of it is around market intelligence, having a system for engaging with your own commercial operations in Europe, and where necessary, having them hooked up with your European Council so that potential infringements or the threat of infringements are reported quickly and they're escalated quickly to somebody who is in a position to make a decision around whether you're going to take any action. So the urgency is real and you do have to move quickly, but what you can't, that is achievable. What you can't have is a situation where somebody on the ground says, hey, I've seen this infringement, we should do something about it. And then that message sits in the inbox of some decision maker in the company for 3 weeks. And then they say, maybe we should investigate. And now you're starting then 3.5 weeks after you actually did have knowledge that something was going on. That's really bad. So you need to have an efficient communication set up so that you can act on information that comes. In some respects, that's a similar story for a defendant. Now, in some situations, a defendant can be well prepared. They may be able to survey the patents that they think could be a threat to them, and they can invest in looking for prior art and things if they wish to make that investment. In some cases, that's not possible. There may be large numbers of patents out there, and it's simply not feasible to do that. They usually, of course, know when they're going to do something that might amount to a threat or an infringing act, but in some cases, it's not quite as straightforward as that. And you see things like the pharma sector where the case law has evolved in the UPC. And, well, we had to have the first case, and then we've had another couple of cases around what is an imminent infringement and what is a threat to infringe and things. And people didn't know what that case law would be when the UPC started in 2023. They only had the national courts case law, which of course differed somewhat in different countries. So the defendant can do a certain amount of preparation around that. But again, I think that a lot of the preparation they need to do is around internal communication. So you may or may not be able to identify the patents that are a threat. And if you can decide whether to work up prior art, etc. But you need to engage with the technical team who know how the product or the process or service, whatever it may be, how does it work? What are we going to do when we get an infringement action landing on our desk, or we're talking about a PI, something that is very, very urgent? We're going to have to pick over that, see if they know how it works. Have they got it right? What arguments can we bring to bear? You need a strong engagement with the technical team. You also need the technical team probably in communication with the commercial team to look at what the effect of this is going to be, right? If this injunction is granted, is it Armageddon, or is it just that we'll have to do something, we'll have to stop supplying for a little while and put it back on the market with some slight tweaks to it. There's a huge spectrum of the real impact of that. And that's important for the business to assess how much to invest in fighting and whether to look at settlement options, etc. And it also feeds in with additional input from the commercial team to the arguments that might be raised around the balance of commercial factors between the applicant and the respondent in the PI decision. So you need to draw some from the technical team, but also the commercial team. And that commercial team is going to help you understand what the impact would be. Maybe it's not just the impact on you, but there are customers, there is the market. How substitutable is this product? What will the knock-on effects be if you have to switch off this part of your service? All of these things are a kind of interplay between some technical people and some commercial people. And I think the preparation here isn't necessarily having those conversations in detail, again, without knowing about one or two or a few patterns that you expect to be asserted. That's not really feasible. But the preparation is, who are these people? Can I get them on the phone quickly? Do they talk to each other normally? Does the technical team ever talk to the commercial team? Are they unknown to each other? If I'm sitting in Los Angeles or in New York or in Tokyo or in Shanghai or something, are all of those people in Germany or Italy or in France or something, do I know them? Do I have the right contact details? Are they going to be out of the office because it's the summer? And if so, who is their alternate, etc.? So getting communication and lines of communication drawn up between the in-house legal team who have got to think about this risk and the people that they need to then draw on to assess what the risk really is and how to deal with it in a commercial way. That's really important. And of course, engaging with your external counsel about exactly what you're going to need to do, what will be relevant in terms of the commercial arguments you might want to bring. How would you deal with any potential workaround situation? All of those sorts of things. So you absolutely want to have your external counsel on board and involved. But again, unless you're looking very closely at a small number of patents, it's probably not feasible for many companies to really talk in much detail to their to their external counsel. They simply want to have them lined up and ready to be brought in to then deal with that information they gather from inside.
I think your point is extremely important. That I mean, that's obviously an experience from you, and I think that is something I can very easy understand. That in the case of an infringement, you start to ask questions to people who you never saw. You don't know who is in charge for this or that question, and you need assessments from them, and that completely out of the normal business. So it comes from outside. There is a time pressure, and now simply to find the right people to get answers, to get estimations, assessments, evaluations, whatsoever, is a huge challenge. And the bigger the companies become, the more tricky is that. So who is really in charge for that? I think that is something which is absolutely, I mean, that is time consuming, absolutely. And also it's not my daily business. It's simply came in and now I have to act. So that's fascinating. I have a question which comes from Udo Gennari, and I think that is a really interesting one. And he deals a lot with small and mid-sized companies in Europe. And his question is, what is your experience or recommendation? Because I have heard the position that the bigger the companies become, the more interesting is it to deal with national flexibility, so to speak, and the smaller the companies are, especially even when they have investors in it, but basically the smaller the companies are, they should go for UPC to get something which is fast and much cheaper than national litigation. So does that make sense to think in that way? So what is your perspective on that?
I can certainly see the sense in thinking that way. I mean, the way I've thought about it is that the UPC, and more particularly the unitary patent, in the sense that locks you into the UPC, is a kind of trade-off between flexibility and simplicity. So if you want to preserve the huge range of options and possibilities that you have by being able to use the UPC or the national courts in whatever kind of combination that you can come up with for a given situation, then traditional European patents, probably kept opted out until you may need to use them, that preserves all of those options with minimal risk that a larger competitor who's got an eye on your patent's going to come along and revoke it in the UPC. Not that we've seen that much activity around that, to be fair. But on the other hand, if you just want to know what you're doing and keep things simple, then the UPC is one system and you can ignore the rest. And it's one system which, by and large, I still think is structurally quite favorable for patentees. I think if we look at overall outcomes, you see it's kind of just under 50% roughly, comes and goes, but roughly just under 50% success, valid and infringed patents in infringement cases. But the setup of the system, the availability of the patentee to choose a division, the deadlines for responding for defendants, etc. Generally, I think that's still mostly favorable to a patentee. So I see that as that kind of options versus simplicity trade-off. And I can see that for a smaller company, it may be that the simplicity of knowing what they're doing, they know what the renewal rates will be for the unitary patent. They don't have to worry too much about whether they should have validated it in I don't know, Italy, because that becomes relevant later. I can see an attraction of that, but you are then locked into the system. You're locked into those renewal fees. You can't prune it down, So it's a choice to be made, but I can certainly see the logic in the position that you explained.
Yeah. So overall, and when we don't know anything else, so that makes sense. And but of course, the individual case, it depends. The classical answer is it depends.
Obviously, yeah.
Obviously. Okay. So a funny thing is, whether it's funny or not, but it's I think it's funny that we have now two institutions in Europe, the European Patent Office and the UPC, which can think in a different way about the validity of a patent. Of the same patent, and that is interesting from a pure theoretical and academic point of view, but it has very practical consequences when we see an opposition at the EPO and when we see UPC litigation. So what would you say? How can we, or what is the recommendation to manage that? And especially, how high is the risk of different outcomes here? What is your experience?
Yeah, I mean, it's certainly the risk is present. It is a theoretical risk. I must say it's not something which I've got kind of hard numbers on, but the risk is certainly there for two reasons. One is that the two forums don't bind each other in the sense of if one revokes a patent, the other one doesn't have to follow, or vice versa, I suppose, more relevantly. And also that we see a degree of divergence between the case law of the UPC and the EPO case law on some important points. And so the risk is more than merely theoretical, in the sense that two different tribunals might come to a different decision. They are doing so with subtly different approaches to making those decisions. And I think that's particularly evident around Inventive Step, where you see that the UPC has gone its own way. And it's coming from the UK, I'm rather used to this in the sense that everybody says, oh, this shouldn't ever make a difference, but we are going to do it differently. So you have to imagine that occasionally it will make a difference. Otherwise, it wouldn't matter at all. So I think there is that risk. Now, how do you manage that, and what do you do about it? Well, I think that what we've been talking about in the last minute or two is the sort of substantive outcome. But of course, you're dealing with two processes that operate independently with completely different timetables. And I say that I know that, for example, the EPO will try to accelerate if there is a UPC case that is ongoing, for example. That can happen, but fundamentally they're different time scales. And if you look at the one end of the spectrum is that a patent grants and a claim is filed that day. And that, again, is not theoretical. That has happened. The 9-month window for opposition will run until maybe we're pretty much at the hearing in the UPC. So irrespective of what the EPO might think about trying to accelerate sort of the later stages, let's be honest, 9 months, you're through most of the UPC action unless it's a particularly slow one. And then the patentee has to have time to respond, and then the OD's got to look at it and things. So it's running on a completely different time scale. And so in terms of managing two things going on at once, I think you've got to look at a spectrum of circumstances, but around the two ends. One is that oppositions are filed much earlier. Somebody's paying attention to competitor patents granting, and they file oppositions, and then at some stage down the line there's litigation. And in that case, the opposition may be well progressed. It may even have been determined at first instance and be on appeal. And that is a totally different situation, really, to the situation that I described a moment ago, where the opposition is following, because the UPC is not showing appetite for staying proceedings. So if you've got an opposition that is coming along behind, even if it's being accelerated, the likelihood is the UPC isn't going to stay, and the UPC will decide first. On the other hand, if the opposition has been underway for a long time, even if the UPC won't actually formally stay it, you might have a TBA decision that's going to come out in the near future, and that will have real effects. Because what's going to happen is that, let's imagine the patent gets upheld in the UPC and an injunction's issued. If you're the defendant, if you can't get that injunction suspended pending appeal or stayed because of the EPO proceedings, etc., you'll have to comply with it. But it may be that the patent then gets revoked within a few weeks. So the impact on you may be very different. It also will, in time, we'll see cases perhaps where the time scale is longer around a defendant has paid damages, or at least the damages are being assessed, and then the patent gets revoked later, and that again will have a different effect. But most of the time parties settle. So these kind of long-term effects aren't seen in as many cases as you would think, because patentee gets an injunction. Of course, there may be an appeal, but that often leads to a settlement. Patent gets revoked at the TBA. That may also lead to a settlement if the injunction hasn't been issued yet. So these things, these really sort of significant events around the patent and the litigation often lead to a settlement, because the parties simply can't take the risk that they can't overturn that result, or in the case of revocation, obviously it may be the end if that's the TBA. So I think one has got to look at these completely different scenarios, and then in terms of coordinating between them, you've got to look at which of these forums looks most important. If I've got an injunction hearing coming up on a permanent injunction and the TBA is way off, I might feel the need to frame my arguments for the UPC in a way that is best for the UPC, not best for the TBA notwithstanding that ultimately that might be very important if we get there, because you've got to get through and resist that injunction first. So you've got to coordinate in a way that pays respect to the timelines and which jurisdiction is going to be important to you as a litigant in the nearish future. And you've also got to think about other countries. And the UPC is a very important jurisdiction, but it may be that you've got litigation going on in other European countries as well. So you're already in that scenario coordinating between them and reviewing your arguments, looking at consistency, etc. But also the EPO is going to be important to those. Most of them are slower. And of course, the EPO, if it revokes the patent, will revoke it for those other European countries, whereas the UPC decision won't directly affect them. So I think it, as ever, it depends, but I think it depends very much on those different timelines and where you sit on that spectrum, and then perhaps where are the most commercially valuable jurisdictions that you're fighting in.
So you already mentioned it, more or less, that we have, of course, countries which are not a part of the UPC jurisdiction, but de facto we see a kind of extension of the European patents, and we had cases, especially with UK, on that. And the question is, how do you see this development, these evolving territorial reach? What will be, so first, what do you expect, how that will go on, and what does that mean for the coordination for the companies when they go for a European litigation? What do you see here?
Yeah, I mean, so much to say on this, and I think we've got so few minutes left.
We have just 2 minutes left.
So I think one is, it's of real interest. You know, American companies that I'm talking to, they are at least broadly aware of this, and it's of real interest to them. And there's a couple of reasons. One is that at some level, although it's a complication, it's also a way of simplifying things in the sense that you can cover more of Europe with one case, potentially. And especially as an outsider looking at Europe as a foreign region where you're trying to understand all of these nuances of different courts and things, that has an attraction to it. So it's not just the efficiencies of you're getting more out of a single piece of litigation if you cover more countries, etc., but it's just simplifying things in a way. The other is that there is an interest in the fact that we don't really understand what the boundaries of this extraterritorial jurisdiction are, in the sense of what patents can be used as foreign patents in a claim that relies on extraterritorial jurisdiction. So you've got to base it on domicile, but what kind of foreign patents can you assert? And there was a fair degree of interest in the case that was brought against BMW not in the UPC, in the Munich Regional Court, I understand, where an American patent was asserted, and that gained some attention in the circles that I move in on the West Coast. I think the other part of it is the UPC offers quite a large, well, the UPC territory covers a lot of Europe, and so this need to find domicile is simplified to some extent. But I think what we're also beginning to see is some boundaries being drawn around when this extraterritorial jurisdiction can be used in other respects. So we saw the Dyson and Dream referral. Let's see how that pans out as regards authorized representatives. But I think there was also a case I saw come out of the Hamburg Regional Division a couple of months ago, in a case brought by Nixu, where the court examined the application of Article 8.1 of the Brussels regulation and whether defendants were closely connected in the context of the defendant domiciled in the UPC region infringing a UPC country patent, and the UK company was alleged to infringe the UK patent. And did that count as closely connected cases with potentially irreconcilable judgments? And there, the court decided not. And you see a certain logic to that in that they're different patents. So if you get different decisions on them, then those are not intrinsically irreconcilable. At least that's looking at it in a more traditional sense. I think you also see that what defendants need to think about is how they can react. I mean, no defendant, I expect, is going to be relocating its companies, right? It's just infeasible, and there are too many other things to worry about. But how do you react to an extraterritorial claim brought against you? Do you simply resist it in the UPC? Do you do something like happened in the BMW case and go to the foreign court, in that case in Texas, and get an anti-suit injunction or some other type of relief to try to cut off the application of that extraterritorial jurisdiction? Do you file for invalidity? I think that's a really important point. If you look at the Fujifilm decision from the Court of Appeal in June, to me, that suggests that defendants are better placed if they filed revocation cases earlier, because at some stage, the UPC is going to make a decision on the UPC patents, and it's going to then have to decide whether to progress the foreign infringement cases if it's accepted jurisdiction over them. And it may or may not stay, particularly if the UPC patent's been found valid. And if there's a decision expected on the revocation case from the foreign court in the relatively near future, that should factor into that decision. Whereas if the defendant is saying, well, I see the UPC patent's been found valid, but I'm now going to go and file for revocation in whichever country, I can't see the UPC being impressed with that at all. And it's going to move towards progressing the foreign cases. So I think that piece about how to react is still evolving, but you can see some ideas flowing from analysis of the Fujifilm decision as to how to do it.
Thank you very much. Thank you. And thank you also to make it as short as possible. No, it is fascinating and it's complex, and it is absolutely necessary to make a deep dive on that, and otherwise the consequences are not clear for the companies. I think that is extremely important. So thank you very much, Chris, for this discussion today. Thank you for taking the time. To the audience, we are organizing right now fireside chats around UPC and the unitary patent. If you want to be a part of that, write me a direct message. So experts are there, and we have also companies already which want to be part of it. It is organized by us as a non-public forum where the interests can discuss with each other in that forum. In addition, we will be back next week. We have the next IP Business Talk, Wednesday, the 26th August, about green tech with Hermione Thompson and John Leeming. I'm happy to see you there. So thank you so much, Chris, for being with us. And now I learned that you are very close to your vacation, so I hope you enjoy your stay in the good old Europe, in this case in UK.
Thank you. Well, it's been a pleasure, and thanks for the opportunity to come and speak to your audience. It's been very, very a great pleasure for me, and I'm looking forward to my vacation.
Bye-bye. Enjoy.